All right, so welcome to Bulletproofing Your Brand and Your Business. My name is Ashley Kirkwood. I'm the founder and principal attorney of Mobile General Counsel. And today we're gonna go through 3 of the key things that you need to build a bulletproof business. You have to talk about the formation of a business, your trademarks, and your contracts. To me, those are the 3 pillars of a fully bulletproofed business, because those are the 3 areas that I see smaller and emerging businesses have the most problems with. The first thing you have to consider is what business entity will you use to actually form your business. I always tell people to really heavily consider whether a nonprofit is actually the entity that you want to have. And so for a lot of people, once they find out all the liability and all the risks and the high probability of like you doing something wrong and it being an actual federal crime, they're not really interested in having a nonprofit. 2 people come together and start selling goods. Then you have a partnership, unless you have some contract between the 2 of you that really well defines your relationship and says explicitly it is not a partnership. And the one that is the most common is the LLC. And they're common because they're easy to start, pretty easy to maintain, and relatively inexpensive to file for. Now, the corporation is ironclad. Think Walmart, like that is a corporation. If you were to sue Walmart, you wouldn't even know which individual necessarily you could come for personally. Now, let's get into some of the things that your business can own. I call these your intellectual property assets. So we'll think about the name of a business. If you're looking at your business name, your business entity, and do you have a state or federal trademark, these are some questions that you all can use to actually start figuring out what the businesses that you work with need. Have you done a federal trademark search on your business name? Most people have not. What they have done is a Google search. And if they don't see anything on the first page, they assume they're good to go, which is not the case, because I've had several people come to me multiple years after starting their business, and they say things like, I thought I had this business on lock, I thought I could own the business name, but now I'm getting a cease and desist. What should I do? And a lot of times I'm like, you're gonna have to cease and desist. So these are 3 questions you wanna ask to an entity prior to counseling them on all of the other aspects of their business. And most businesses you all work with are primarily concerned with making money. So one of the things that I tell them is if you don't have your business protected and you don't have these elements in place, it can cost you a lot of money down the road. Legal is one of the only threats, outside threats to your business that can and has bankrupted several businesses. Copyright is a very nuanced area of the law, but essentially your copyright is your right to written and artistic works, if you were to break it down very simply. You cannot own an idea. So you just can't. Like, no one can own an idea. And because you can't own an idea, what you can actually own is a created work once completed. People who are bloggers, and they're always creating different blog posts, they would definitely want to have a copyright. People who do photographs actually have they have copyright protection over their actual photographs, which is why if you work with a photographer, you want to make sure that you have the right to use that stuff for business purposes, for your own purposes. What I've seen and what has happened before with someone that I've worked with is they were excited, someone, you know, a big celebrity wore some of their products, put it on Instagram, they retweeted the photo, and it was not the celebrity that came at them and threatened to sue, it was the paparazzi that came at them and threatened to sue because they actually owned the copyrights to that image. Patents protect inventions. So it's a technological invention, and the federal government wants to make sure that you have done enough creatively to actually protect the invention that you have. A trade secret would be something like a client list. It's something that is unique to your business and the way that it runs. Anything of that nature that you use to protect and help run your business could be considered a trade secret, and you want to get that protected. Trademarks are anything that actually differentiates your brand from another brand. And in the United States, we're very blessed because they allow you to trademark any number of things. One of the larger beverage companies has trademarked the sound that it makes when you pop the cap. Tiffany's, that actual color blue is trademarked. So another jewelry company can't utilize the color blue. So when you're explaining this to your clients, they're like, well, what's the difference between a copyright, a patent, and a trademark? The vacuum cleaner is a great example because it is an invention, or it was at one point. The brand name of the vacuum cleaner could garner trademark protection, and the actual manual that came with it could get copyright protection.
Mobile General Counsel today taught me quite a bit, and the directions in which I would like to send my clients. I'm a trusted advisor and consultant for startup and small businesses, but I don't have the legal realm or knowledge, and I'm glad to know that there's a source out there to recommend them today.